I'm Pinko, the Mud Hog. Am I live?
You're live.
Hi everybody, I'm Pinko, the Mud Hog. Or you could call me Aaron, GBA James Bethel. And when you're putting a motion in the courts, you typically have to put in an affidavit in support of the motion. And you have to show your cause and everything on the motion, like the laws and the statutes and all that, usually. Or you could put in a statement, a simple statement of facts, or a affidavit, or call it whatever the hell you want. But you have to swear to it, and you'll be able to support it, the facts being the way they are. Typically, you can mention things like, I see no evidence of this, I see no evidence of that, I see no evidence of this, that, or the other. Instead of moving the court to do something with the evidence, you put in a factual statement saying, I see no evidence of this, that, and the other, and the law says that these things are supposed to be done, and you put it on record. Now, the court has all kinds of suicipante powers that they use. Now, suicipante means by your own will, or by my will, or I'm spontaneous, and this is my act of spontaneity, or something to that effect. I don't know Latin, and nobody will teach it to me, so. Their power extends to do just about anything they want to do to affect justice.
That's because of the Judicature Act of, 1871. They commingled equity and the at-law in rem side, and now they reach into equity whenever it's convenient for them. And
actions
they call it
at law
balancing of equity.
And bills in equity are hereby combined to one thing called a civil action, I think, is what they say here in Nebraska. But that doesn't change anything, because basically it says that in the beginning of our civil statutes here, it says that inasmuch as the common law doesn't conflict with these rules and regulations, these statutes and codes, then it will be applied. But where there's a conflict, it's always the code that prevails. And then you go further in the code to one of the other codes further down. I can give you the codes, or Derek can give you the codes eventually, or you can look for it for yourself, see if you can decipher it. But it basically says, if you can't get relief under this code, you can go to the practice heretofore in use to get relief. So when you're looking at all these codes and statutes in whatever state you're looking at, there's always annotations attached to these things, and the annotations are case cites usually. I mentioned the beginning of the civil procedures in Nebraska. In part of that chapter, you'll see something that says writs of prohibition are abolished by this code. And they're right. Writs of prohibition are pretty much antiquated by the civil procedures that they lay down.
Sure, different jurisdiction.
But when you get to this statute that says if you didn't get relief under this code, you can go to the code heretofore in use. It right there in the annotations, there's all kinds of writs of prohibition that are lit up, and other things that are outside the civil procedure statute. It's kind of funny because they seemingly contradict themselves, but they're really not. About 5 years later, I had somebody ask me about that statute and asked me to find it and whatnot. And in the course of finding it, I happened to read the statute after that one. And I never really read any further than I need to. And I really don't know the code very well. These people are the ones that point out to me 99% of the time the remedy that I need to fix them. And then they don't do their job, so that's moot. But the next code basically says that when you lay an action down, the procedure you lay out in your action, inasmuch as it doesn't conflict with the current procedures in use, will be used by the court. That means that your paperwork and the way you want things done is basically a contract to the court. It doesn't have anything to do with procedures or regulations, or, well, we just don't have time to do that, Mr. Bethel, because justice is a very slow, ponderous thing.
Well, they use the guise of justice, but really they should be calling themselves a court of contract, because that's what they are, a court of contract.
I was doing an appeal one time where the process is a time-sensitive thing, as most of you probably know by now. If you waste time, then you are,
You acquiesce.
you're an idiot.
Long-suffering equals...
Yep.
Long-suffering equals acceptance.
Yep. Long-suffering equates to consent.
Right.
And consent removes all error. So basically, when I made my appeal, it took me, I think, 4 days to structure the paper for the appeal. I threw it out the record. 30 days later, I get a response. It takes me, I think, 7 days to do my response to their response, and it takes them another 30 days to respond to me. In the 30 after the 30 days response was up, they sent me another letter saying that I wasted my time to bring my appeal, that I had expired the 60-day time limit, and that I could not get the appeal because of that. I sent them a pretty nasty letter telling them to shove whatever concept of justice they have up their ass, because they're the ones that laid waste the time limit. If anything, they should have extended it because they took so long in response to my paperwork. And I tallied up my 11 days and their 60 days and showed them that that was the way it was. And, of course, that doesn't matter because they do what they want to do.
Because it's a...
how they do business.
Well, they're under military occupation. They are administrating on behalf of the Commander-in-Chief of the United States, for which all property is vested into. They're administering a trust, a public trust. And they have a vested interest in that trust as part of their retirement.
So when you're doing a motion, and you do it not in the sense of a regular motion, you're doing it in the sense that you're just bringing facts with personal knowledge onto the record. It's up to the court to make a determination on whether or not they're going to follow the law, right? So your motion isn't necessarily asking for anything or saying anything. What you do is you put your facts down. It could be anything. It could be anything. Like
grass is blue.
Well, for instance, in order for a corporation to show up, any legal person to show up in a courtroom, they have to provide their authority, basically the charters. And without the charter and the president of the bank and the power for the president to assign legal matters to an attorney, and the attorney holding up that power signed by the president, with the president holding up that power granted by the board of directors, and as he's holding up that, he holds up the charter as well.
The charter, yeah.
Right. All that is agents and agency, and they have to provide all that in order to show the person in court. Okay.
And that would prove standing or lend to standing.
And that would be one of the examples you'd use to put in a motion, saying basically, I see no evidence that such and such as a legal person has appeared in court. And what does not appear does not exist. That's a maxim. There's a number of statutes that provide for representation of parties, ratifications of commencement, which would be the document giving authority to somebody to do something on somebody else's behalf, like a commission or a license or a bond or anything of that nature. It doesn't matter what it is. It's an assignment of some form for one person to do what another person needs done, and without the assignment, it would be illegal.
Well, that's what everything boils down to: assignment and acceptance.
When you get towards the end of the motion, your statements are at the beginning, and the reasoning for it is at the end, which is the laws that are supposed to be being upheld that aren't.
Well,
and
jurisdiction's never been established.
See, and that could be one of your statements.
We've got cause of action, but we don't know the nature.
I see no evidence that jurisdiction has shown up on record. But with jurisdiction, you got to be careful, because the only way to challenge jurisdiction is via a special appearance. The only way to make a special appearance is if you haven't contracted or joined suit yet. So typically when you sign a ticket, you sign it without restrictions, you've joined suit. And consent removes all error. And it's a general appearance, and a general appearance also removes all errors.
Yeah, presence of the body waives the error in the name. But if you're quick enough and sharp enough to understand the doctrine of idiom sonum, you can rebuke that and put the nail in the coffin on that aspect.
Not if you've signed a ticket.
Well, if you properly endorsed it, yeah.
At the same time, when you're challenging these people and making these factual statements and everything, typically the judges will ignore you. They don't give a shit to hear anything you might have to say, especially if it contradicts their ability to make a profit, I imagine.
All crimes are commercial. CFR 277211.
So you'll find that the statute that lends to the courts doing things sua sponte, it's something that's usually found in the court's administrative procedures or in part of the civil procedures, usually.
On the court's own motion. I heard a judge say it one time, that's why I know it to be true. She said, sua sponte on the court's own motion, and again, they're talking about a fiction. She's making you believe that she's not doing it. It's the court. It's magical, remember?
Yeah, you always want to keep this stuff in the first person. You don't ever identify the persons. You always keep it in the sense of the first person
or third person, so you can show that you're not the estate. Why do you keep reciting it? You know, that's what Karen Lynn Noakes did to me one night, or one day in court. She said, why do you keep referring to Derek Chaton Gonzalez? Well, in as much as I would like to be a person, I can't be. So I will continue to refer to Derek Gonzalez just as it is, in a state, you know, a thing.
Under statutes, the way they'll describe the sua sponte is often done in a variety of ways. One of the most common ways is that it'll say the court, in its discretion. That's another way of saying sua sponte. So anywhere where you find these codes and stuff that are necessarily supportive of your position, you can use them in your so-called motion to get the court to do the right thing, basically. They'll probably railroad a lot of this, and your appeals can be such that, you know, it's something that's already on record and whatnot. So it's never been rebutted. It stands as evidence in fact. So the appellate courts will come up with other ways to thwart your appeal. But some of you might still win.
One of the other things, instead of doing motions, I like to require.
Well,
I require.
You are requiring
full
it.
disclosure. I require, because a motion is
That's
actually
like
to ask.
So that's a precipe. A precipe is you ordering somebody to do something. And typically when you write up a precipe, so like for instance, to get a writ of habeas corpus, you'd put in a precipe for a habeas. And you'd also add, with your precipe, you'd write up the writ for the habeas. It's kind of, you're doing them a favor, you know, and it kind of helps them. And it also shows that you know more than they want you to know about what you're doing too, because you're able to write up their orders and stuff for them when you're wanting them to do a thing. And it kind of helps them know that, you know, maybe they shouldn't trifle with you so much. You might be more argumentative than you're worth.
In lieu of an injunction from the Superior Court, I will accept this court's motion for stay until a final determination has been made. You make it their idea.
Should I be responding to these?
You can respond all day long. That's fine. I got time.
Legal question. Why? What do you mean legal?
Well,
how?
because I talked to him about lawful, not legal. I'm way past legal at this point, because legal is the undoing of God's law. So when they threaten me with practicing law,
Not
I
necessarily.
laugh, because the law is well established. I ain't practicing anything. I'm enforcing it.
I think things that are legal and lawful are kind of synonymous.
No.
To an extent.
In an aspect where murder is illegal and it's also unlawful, I would agree with you. That's the letter of the law and the spirit of the law all combined in one, and they mirrored the law of the Heavenly Father, the law of man, the law of
I can
the
see what
land.
you're saying. Homicide would be a legal thing, and murder would be a lawful thing, in my mind. Because in our statutes, it says basically when you're looking at the common law and you want to decipher common law from statute, for instance, in our criminal code, all the statutes are, there are various criminal codes like theft and murder and stuff like that, rape. There's also things in there called manslaughter, homicide, statutory rape,
Murder
and shoplifting, for instance. Now, we all know what theft is. There's no real description for that. And rape, rape is. Murder, pretty much know what murder is. No description for that. So when you read these codes, you'll find that murder is punishable by such and such. And you get to theft. Theft is punishable by such and such. You get to shoplifting. Shoplifting means and is punishable by such and such. You get to homicide. Homicide means and is punishable by such and such. Statutory rape means and is punishable by such and such. See, what they're doing is they're blending in their offer of what right and wrong is, as well as what we know to be right and wrong.
They're defining the words.
Well, they're defining those particular causes of wrongful acts so that people can use them, I guess. But you don't necessarily need them, at least not on the private side. If somebody's raping a youngster, you don't call it statutory rape. You call it rape, and you kill them. At the very least, you chop pieces off of them and maybe sell them on the black market.
Shit. And then give the proceeds to the judge,
Well, yeah, because they're going to want their cut.
Here's my bill.
I'm supposed to be reading some of this, huh? I can't really read very well because they are liable for the person because they created it. Yeah, they are liable for the person in a way, but so are you.
Grant it to them.
You see, because since they created it and you've been using it all your life,
usufruct, baby. If you don't know what usufruct is, usufruct.
You're using something that somebody else made for your benefit at their expense and without payment to them. So you have a resulting trust.
But there's a conflict in the way that you said that, and herein lies the problem.
Hit me with
They took everything.
in the first instance?
That was substance within the economy.
Well, are you telling me that necessity trumps?
Necessity absolutely trumps law, but you have to be careful with that.
Huh.
Because they use it all the time. Against you. Not in your favor as they're supposed to.
So he pointed out the only crutch to that to that process that I just said. When you're in any situation, the sheriff taking your car and giving it to a private third party, that's a resulting trust. If you notice him of it, and you stay on top of the notice and opportunity to follow through with the enforcement on it, as the beneficiary and the grantor, whether it would be voluntary or not. But you still have to stay on top of them. And notice and opportunity is primary. Due process is primary to keeping it in equity. And you always start with their first person. Like I said, I'm Aaron, DBA, James Bethel. There's a reason for that.
I use DBA because they can presume and assume DBA means dumb bastard. You know,
I don't give a shit what they assume and presume. You act accordingly, right, or you don't do business.
I'm saying, write it out. Doing business as. Don't use DBA. You know what I mean?
Yeah.
Don't give them an opportunity to presume and assume. Well, we thought he meant dumbass over here. And
because everybody that puts DBA does?
Sure, it doesn't matter.
It does matter. Because if you say something stupid like that, I'm going to put your stupid ass in your place.
Yeah, well, it's all semantics at the end of the day. You know how it is. You've been there with me.
Right. For the most part, you get to a certain point, they're not going to play too many semantics with you because you're too argumentative and quick on your feet to be semanticized. Not really, but... I can't read that at all.
No, I don't think you can zoom in on them either. Bill Collins, someone needs to tell them that... I can't read the rest of it. Yeah, you can just scroll through them.
One of the ways you can get to these people that's really funny for you to use, I think it was Robert Fox that pointed this out. Robert Fox pointed out the motion thing too. He was a good man in my mind. One of the things he does, he'd go in front of juries, and when the prosecutor opens the ball, people sitting there listen, and then you have an opportunity to speak. So what I do is I walk up and I say, by a showing of hands, and based on what you've heard so far, how many people here believe that I'm innocent? And nobody raises their hands, of course. So I turn to the judge and I say, dismiss them, all of them. They're incompetent. And he goes, whoa, Mr. Bethel, wait a minute now. Now, y'all understand that Mr. Bethel, he hasn't, nobody's proved anything. He's innocent, you know that. You know, they're all nodding their heads. Yeah, you bet, we know that. So you know Mr. Bethel's innocent then, right? Yeah, oh yeah, we know this. Mm-hmm. Well, he goes, there you go, Mr. Bethel, they're all okay then.
Well, is that their verdict? Is that their ruling? Innocent? I'm confused at this point.
A
moment ago, I was guilty as hell, and now all of a sudden the judge says I'm innocent, and I'm innocent. And I think these guys are all biased. They're all fired now. Thank you for proving that, Judge.
In the civil procedures, there's an area deals with juries. There's a couple of areas that deal with juries, and it looks like they've got a dual set of codes going in the same place at the same time. But I think that's the position between the occupier and the actual. So buried in this section, you'll find the issues before a court. There's only 2 issues before a court. This is a little bit of legal training for y'all. There's 2 issues before a court, law and fact. Now, when a jury sits and they are, the judge talks to them, he specifically asked the jury, in my case, whether or not it was okay for him to tell them, interpret the law for them. And they said, yeah, that's fine. So right there, they said that they would not handle any issues of law.
That's an abortion of justice.
That's a special verdict, and it's for rendering on facts only. That's all they're there for. And they get ushered out of the courtroom before anything else is applied because most of these people don't want them to realize what's happening or not happening. It doesn't really matter. But what matters is they have the power for general verdicts written in the statutes. And it says specifically that general verdicts are which the issues are decided on law, fact, both, or neither. And if you understand what I'm telling you that the people have the power to determine the law and the facts in the courtroom under statutes in all the states. Now, when I point this out to the courts, they get kind of cagey. And they tell me that I'm misinterpreting things and whatnot. And I'm pretty sure I am misinterpreting things. But I can't get any clarification on that because they won't interpret it for me after they tell me that I've misinterpreted it.
Yeah, because we, Mr. Bethel, we apologize, but we don't, we can't practice law here, and we're not your counsel.
Right. So let me get this straight. You made a determination that I'm not making a determination. When I get you to try to explain to me how you tell me that I'm not making a determination, you tell me that I've got to go to an attorney, and he's going to tell me why you know that I'm not making a determination. Because that's what you do. You go to an attorney. I had a friend sitting in the court, and when she asked the judge how he got to that conclusion, he told her, go get an attorney, and the attorney will tell you why I made my decision.
I fucking love it.
That is about as dumb as it goes.
Maybe you should talk about simplifying it. The gal that takes the dictionary into the courtroom.
Oh, yeah. I have a friend of mine that when I pointed some of this stuff out to her, she's pretty tenacious. She was born abroad, but she has American parents and whatnot.
Been in many court cases, right?
Yeah.
This isn't a one-time fluke
because of her children.
Right.
And the men she chose to be around. So she'd go in there with the dictionary. And, the first words out of their mouth, like, are you such and such? She starts looking these words up, and she's like, I don't understand what you mean. This definition alone has 7 different ways that it can be taken. Can you be more specific? I'm all bugged out. Ooh. That's kind of neat. I like your camera on here. It's got some high def. I'm all bugged out on the camera. I'm probably freaking people out. I'll stand back, people, and look more authoritative. Wait.
There you go.
There we go.
Tell them how it is.
How's that? Serious look. No smiles.
So the point being made there is because they won't define the words.
How can you understand it?
The ability to define the words.
How can you understand it? How can you come to a meeting of the minds?
You can't. And that's what it's all about in their contract courts. It's about coming to a meeting of the minds through a deceptive language, which is legalese, dog Latin. One of the other things I noticed, he did this or he did that. Now, the law acts very specifically. So what exactly did this entity do? Because if I brought a claim that frivolous, I'd end up having to go support it with a bond, and they would liquidate that bond just after they told me, hey, he brought forward a claim for which relief cannot be granted. You can't bring a claim saying he did this or he did that or he did this or he did that.
In a criminal...
It's specific. What did he
Well,
do?
in any situation, but in a criminal situation in particular, I do this to him all the time, and it's not in statute. So how does he do it? Well, because it's just and reasonable. When it's called a bill of particulars. And what you do is you basically order the other party to provide a bill of particulars. Now, the bill of particulars is nothing more than a series of questions that you require answers to. Specificity on the case. So they're going to list that you've done these things, and they can only put down what the statutes show because they're practitioners. They have not perfected what they're doing yet.
But the statutes are vague and ambiguous.
The statutes catch activities, and so they have to be broad and overreaching in order for them to work, and that broad and overreaching effect has to be put in the paperwork, and they're not specific enough for you to answer the questions. In one guy's case alone, I counted 33 instances of or and I used it to my advantage, and the judge said that he didn't have he wasn't going to grant the bill of particulars because he didn't see that there was any reason why the guy couldn't plead to the claim.
And that's piracy on the land right there. That's collusion, conspiring, extortion. Well, they haven't got to the extortion part yet. Not just yet. I mean, I guess they are extorting you of your time.
How about these people lie straight to my face?
Oh, yeah.
And when I looked it up and found out that I was duped, after a while, you do not believe anything that they're saying. In fact, they're lying because their gums are flapping. Plop, 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 plop.
What kills me is when you defeat them, David and Goliath type style, with a little pebble that they can't overcome, and they don't even have the audacity to apologize. There's no humility in what they're doing. They have no shame.
They held me for over 200 days, and they released me with 1 piece of paper and 2 sentences.
And never provided remedy.
I have 4 certificates of birth and 2 sets of parents. 2 social security numbers on the last 2 names. That was all given to me by these people before I was of contracting age. And the second set of parents that they gave me, the guy was a pedophile. He was a state-sanctioned pedophile. Set up for foster care. Keep that in mind at all times. The state doesn't discriminate. So it takes some kids from people and gives them to other people equally.
Yep. All for profit. All for profit.
I'm going to leave y'all with that.
Yep.
Thank you, Derek, for allowing me to speak.
Yeah. Yeah, I don't typically delve into the statutory thing, but I think it's good for people to hear it. So, but
They could be armed a little bit against some of the crap that they are perpetuated against.
Sure.
Because these people all live in statutes.
Well, that's the thing. I take them out of statutes because really, not even the lawyers understand the statutes. Look, you're telling me that I violated the law? No, you violated a statute. Which one of the 66 million statutes out there did I violate? I mean, it's an impossibility to even walk out the door in the morning without violating at least a dozen of them. I'm certain of this. Furthermore, how am I as a man to know 66 million statutes? So let me put this in a negative averment type situation, or an averment.
Bill of particulars.
A bill of particulars, if you will.
I need this, I need that.
Is there a man in this courtroom here today that will claim to know all 66 million statutes, codes, city ordinances, rules, and regulations? So we're all ignorant of the code? Am I to understand that right? So, just things like that to point out. Anyway, stay happy. Do your best to stay free. And that was my brother James. He's the reason that I didn't end up in prison the first go around, because I was a little spitfire and I got zero tolerance for bullshit. And I didn't know what they were doing. And he just kind of laughed. And he goes, "You can chase those statutes all day long, Derek. You look like a dog chasing his tail on the living room floor. For every 5 statutes I found in my favor, the prosecutor found 10 that weighed in his. For every Supreme Court case that I pulled up that was in my favor, the judge say, well, we're not going to accept any Supreme Court rulings in here. 5 minutes later, just to smite me, just to poke it in my face, the prosecutor go, well, Supreme Court ruled in 1995 that, that this action merits this kind of a claim, and we're justified. Now, I'll accept that, he says. Oh, wait a minute. 15 minutes ago, I wasn't allowed to use Supreme Court cases. All of a sudden, the adverse position of this guy, or the adverse position of this guy, is to use the very stuff that I was using in the first place that wasn't acceptable 5, 10 minutes, 15 minutes ago. So just be prepared for that. Best way to end court cases is to do it with paperwork before you get there. That's the best way to do it. That's the best way to get rid of it, make it disappear. None of them have a true oath of office. Not a one of them, guys. So, as far as trust goes, express the trust. Do you see a trust, Judge? Do you disclaim the trust? If they're silent on it, seal the deal. Because if you stay silent for too long, they just move over you. You got to know the next move, and that next move is show a cause why this shouldn't be sealed ex parte, or be it resolved. This case is now sealed. We'll be in camera in chambers to handle the rest of this using Gibson chapter 1 through 60. Henry R. Gibson Suits and Chancery. We're going to express the trust. We're going to express the resulting trust, the constructive trust, how all this manifested into existence, and who we are within the trust. Remember, a trust can manifest without the beneficiary knowing they're the beneficiary. And a trust will not fail for want of a trustee. So that's just a matter of finding out who's going to handle these affairs. Who's licensed by the licensor as a licensee to negotiate this paper, baby? Looking mighty fine over there, prosecutor. Now, just go ahead and keep your mouth shut over there, because in chambers, you don't want to get caught up trying to state facts, because you can't be heard in there. Just like you, as a man, can't be heard in their courts. You can't be heard in there. It's all semantics. It's all bullshit. It's all bullshit until you get in the exclusive jurisdiction of equity. And there's a lot of people that talk crap about it. I'm here to tell you right now, anybody that's done an ounce of research will know there's auxiliary, concurrent, and exclusive. And exclusive is where man finds remedy. Period. Not some of the time, not part of the time, every time. And what I love about exclusive equity is that all rights of the parties, all rights of the men and women involved are protected. So it's equality. Equity delights to do equality. equity delights in equality. Anyway, with that said, love you guys. I gotta get the road, so we'll talk to you soon.